Everyone. So we are from group 6, 3 members, including me, Vương Ngọc Yến, and 2 other members, Lê Hoàng Yến and Nguyễn Trịnh Thảo Nguyên. So today we will have a presentation on case number 6 that our lecturers have given us. So let's see what we have in this case. So now let's start with the case that our lecturers have given to our group. So on the screen is the full case of our group. So you guys can have a look at this to see the information and the facts that includes in the case. Actually, we will have around 1 minute to go over the case. Okay, can you move to the next slide? So our presentations will have the 6 key sections. The first one, I will give you the facts and some facts that we can infer implies from the case to make sure there are no misunderstanding. And we will raise the legal issues and in turn analyze and solve the 2 legal issues under this case. Next one, we will analyze if the case have a different resolution if Vietnamese law applies, and we will give you the conclusion at the end of the presentation. And if you have any questions for our group, please feel free to ask at the end of the presentation. We would be very appreciate that. So now let's start with the summary of the facts. So you can see the case is very long, right? So I will make some summaries for you guys to understand more about the case. So Alice, bought a small bakery business, and this business was surveyed by Church and Happy Home Building Society. And Happy Home Building Society is also the entity that provided Alice with the mortgage, the money to the bakery business. And Chart were the ones to conducted the survey of the bakery business. So here, this is a fact that we can imply from the case, from the sentence, Alice had a note, can we to the previous slides, yes. Alice had the happy home for the report from Chart. So it is concluded here that Chart is employees of Happy Home Building. Yes, can we move to the next line, the summary of the facts? Okay. However, on the day moving into the premise, Alice discovered severe and large-scale railroad when she fell through a storeroom floor and broke her leg. Also, the injuries and the eradication of the railroad delayed the opening of the premise for several months. And after that, Alice had a contract with industrial kitchen fitters to refit the kitchen business, and IKF then installed a new oven, and this oven manufactured by Cinder Inc. Yeah, there are some entities that we highlight on the screen. Is that the entity that will appears in the lawsuit, and a week after the business has eventually opened, the new oven won't function, and as a result, the wedding case was badly burnt and leading to a claim for damages against Alice by the bride fathers. And we notice here is that the industrial kitchen fitters has gone out of business. So in this case, we will see that Alice has the relationships with two other entities. The first one is Charge and Happy Building Society, and the next one is in the connection with the IKF, the Industrial Kitchen Fitter, and the Cinder Inc., which manufactured the new oven. So we have two different relationships as well. We raise two legal issues in this case. The first one is whether Alice was able to bring a lawsuit against Charge and Happy Home Building Societies to claim for her damages. So, or in other words, we will have whether Charge and Happy Home Building Societies was held liable for the injuries and damage of Alice. And the second legal issue is that whether the IKF and the Cinder Inc. be held liable for the damage Alice has suffered the malfunction oven. And in the following, our group will respectively analyze two legal issues, two smaller issues in the big case. Okay, so I will be in charge of the legal issue one is that whether Charge and Happy Home Building Societies be liable for the damage and injuries of Alice. So now we will see under what principles that the legal rule that apply in this case. So there are two. So actually, we are back to the revert lines. No, we are miss some lines here. So before in the case when Charge make a report, he's already stated that this report is for valuation purpose and will not give rise to any legal liability. So which means that Alice cannot apply the contract law into this case, which means they cannot use their contractual relation under this case to bring a lawsuit against Charge and Happy Home Building Societies. So we advise her to bring a lawsuit against Charge and Happy Home Building Societies under the tort law. So why the legal principles of tort law can apply in this case? So we have two main elements to recognize a tort under the US law. The first one is a legal wrong, which means the act or omission that is not authorized by law. So here in this case, we will see the act of causing injuries and loss for others is prohibited under the US law because they want to protect the citizens from the loss or detriment from other acts or other act and omission. The second element is it result in actual loss and damage. It is easy to observe that Alice has suffered several damage and injury from Charge and Happy Home Building Societies, which I will mention detail in the next slide. And under the principle of negligence, a person is liable for harm that is foreseeable consequence of his or her actions. So generally speaking, when someone acts in a careless way and cause an injury to another person, so this under the legal principles of negligence, the careless person will be held liable for his or her actions. So that's why in this situation, we advise Alice to bring a lawsuit under the principle of negligence. Okay, so what is negligence? So I guess that we have familiar with this one, but I just want to remind you guys about this. So it's the omissions to do something which a reasonable person would do, or doing something which a prudent or reasonable person would not do in a situation. So that is negligence. And to prove a case under negligence, we have four elements, right? Can anyone here give me the four elements that we need to consider when coming into bringing a lawsuit under the the negligence? Is anyone here remembered? Because you guys are very familiar with the four elements under the negligence, right? Can anyone here once more time remind the class about this? Can I invite Bảo Ly?
Yes.
Yes, Bảo Ly, can you give me the four elements under negligent should? Right. Do you remember about the four elements? Lee, are you here?
I don't remember.
Yes, okay, that's okay. We will have another person. Uh, can you help me with the question?
Yes, there are four elements to prove a negligence case. The first one that there should be a duty of care, and there's the second element is that the duty is breach, and the third element is about the causations, and the last one is that there is damage in this case.
Yes, thank you so much, Lin. Yes, there's four elements that a person need to prove if they want to bring a suit under the negligence. So now we will analyze in this case whether Alice has like satisfies on the elements in fourth element of negligence. So the first the charge owns a duty of care to Alice, or in other words, we can say that each charge is a reasonable person under this circumstance. So we see that in some circumstances, the relationship between the plaintiff and the defendant might create a legal duty. For instance, about a doctor and a patient, a doctor needs to provide a competent medical care for the patient. However, under some circumstances, the law will require a person in certain situation act in a duty with reasonable care. So it is the case with George and Alice. So we can see that George was already working in these fields and he acted as a surveyor in this case. So he was expected to find out about the obvious defects, the obvious defects within the properties which would impact the values of the properties or cause possible risk to other. So therefore, George were being assumed to have judgment and skill in certain situations to set the standard for others in similar situation would requires this reasonable human judgment and skill. So we can see that trust in this case can be considered as a reasonable person, and in certain situations he need to act in a reasonable care. So that once we conclude that charge on a duty of care to Alice. So let's move to the second element. This chart breach the duty of care in this case. So obviously, yes, because under similar circumstances, a reasonable, prudent person like Charles was expected to have felt about the important facts or information about the bakery and disclose, inform Alice about this in the report, and it include the severe and large-scale railroad would lead to Alice's injury. Additionally, he would have known that someone might have been injured as a result of his actions of not disclosing the information about the railroad, and he would have acted indifferently than what he had done in the situation. He would act in a manner to protect other people, but he failed to act in this way. So that's why we conclude that Chart breached the duty of care of him in this situation. Next one is any damages, injuries, or loss that Alice had to suffer. So we can easily observe from the fact that Alice suffers several injuries and damage. The first one is her physical injury. Yeah, Alice had broke her leg because of the railroad. And the next one is the medical expenses because she need to go to a clinic or hospital to treat for her broken leg. And next one is the economic loss. The Alice business had been delayed the opening date because of her injury and to eliminating the railroad in the property. So the delays in the business would result in the economic loss of Alice. Okay, and the fourth element, is there any causal link between Tort breach and the injury, loss, and Alice has suffered? So in this situation, we would use the actual cause. So it must be true that but for the defendant's negligent act, the injury would not have occurred. So we can see that Chart was bad to conduct or provide the report, but he failed to notice the large and severe right road in the premise, which is a duty, a part of his job, and he fails to exercise reasonable care under the circumstance, and it resulted in Alice's legs were broken and she suffered serious physical injuries, and it's reasonably foreseeable that George's act or omissions could cause him to another person as well as Alice. So we can see that if George disclosed on the information about the right road in the premise, Alice's injuries would not have occurred. So we can see the causal link between the breach of duties of George and the injuries that Alice has to suffer. Okay, and then is there any defense available for George? So in this case, we don't bring out about any defense, but we found a special doctrine that can apply under this case is vicarious liability. So it's a legal doctrine that assigns the liability for an injury to a person who did not cause the injuries, but who has a particular legal relationship to the person who act negligently. So we remember about these special doctrines. It can be between parent and child or employers and employees. And under the U.S. Legal system, the relationship between employer and employees is one of the outstanding examples of vicarious liability. So under this circumstance, the companies or the employers is vicarious liable for the actions or works or deeds of its employees, specifically when the action, works, or deeds are conducted in the name of or on behalf of the company. So this is true when the companies or one of his employees either intentionally or unintentionally cause harm, and the employers would have liable for the activity for the deed of its employee. So vicarious liability would apply in this case, but we have some elements to prove that whether vicarious liability can apply in this case. Can I have the next line? Okay, so there are three elements that need to be present, need to be proved for vicarious liability. So the first element is the person who has committed the tort must be an employee. So we can see that in the summary of the fact, I have already pointed out a sentence in the case that we can conclude that Charles is an employee of the Happy Homes Building Society. And the second element is tort must be committed by an employee. Yes, we can observe easily, right? Because George is the one who conducted, provided the report. So he is in charge of this report to Alice. So the tort committed by an employee is satisfied. The final element is the tort must be committed within the scope of the employment is the range of conduct and activity within an employee can reasonably be considered to be carried out as part of his or her job. So we can see that in this situation, the reports from trust will be a part for the valuation process of the happy home societies to decide whether to get to give Alice the mortgage that she has applied for, she has requested for. So the report is a part of the job to complete the valuation process procedure for his employer, the Happy Home Building Societies. So we can see that he is working within the scope of employment when the omission occur. Because if he didn't work in the scope of the employment and he caused injuries or damage to others, the vicarious liability would not apply in the case. But he's working within the scope of employment when working for the employer. So vicarious liability will apply in this case. So we come to conclusion that uh, in this situation, the plaintiff, Alice, has a choice either to sue the employer, the Happy Home Building Societies, or the employee, Charles. So she is entitled to sue both of them or just one of them under the negligence doctrine to seek damages and compensation for her injuries and loss. So this is the end for the first legal issue. And for the second legal issue, we will have Thảo Nguyên that will get you through with the legal issue number 2. So Nguyên, can you?
Okay. Section 4, legal issue 2. So first, we will introduce the two elements to prove strict liability product. First, there is a defect in the product. And second, the defect causes injury, loss, or damage to plaintiff. So let's jump into the first element. So to prove the first element, we will answer the question, what is machine malfunction? So the term machinery failure or malfunction usually implies that the machine has stopped functioning the way in which it was intended or designed. So basically, it means there is something wrong with the product, and this wrong was not from the user fault. So the malfunction, so there is a malfunction in manufacture. Yes, and for the second element, the defect causes injury. There is an event that the cake was badly burned, and this event led to a claim for damages for breach of contract against Alice by the bride's father, so that Alice have economic loss. Yeah, so there is so the defect causes injury. So however, is there any defenses available for the defendant? Because the cake was badly burned, so the defendant can indicate misuse of product and comparison negligence. The first one, they can claim that she used it in the wrong way, like she chose the option for grease a chicken to bake a cake. For the second, like she baked the cake too long, like The cake needs 20 minutes to bake, but she took it 30 and it cost. The cake was burned. Um, Third, Alice did not read carefully the user manual. So because not read the user manual, she used it in the wrong way. Um, yeah, for the fourth, did not she did not take care the product in right way. Like before, we know the fact that she takes few weeks to open the store, so the product has to be set there and being used, so that maybe in that time she not protect it right way, so it can curse the product where um, there's something wrong malfunction with the product, not from the company who produce. Yeah, that yes. So this is basically what we can think. The yeah. So this situation can partially responsible. So the defendant can use some of these situations to defend of our client. Yeah. So in conclusion, based on the information given above, Alice can sue for strict liability. However, we don't know exactly where the case happened. And besides, instead of person injury, this case is economic loss. So that it just can claim in a few jurisdictions. Yeah, so next, moving on to the second part, which Hoàng Yến will in short.
Yes, we'll continue to find out how this case will be affected if enemy law is applied. So, regarding crowds giving rise to liability for compensation for non-construction damages. Yes, compensation for non-construction damage is a case where the injured party has the right to demand compensation from the reaching party for damage that occurs not due to a breach of contractual obligations. And according to the Civil Code 2015, the condition for the occurrence of non-constructed damages or their actual damage, namely direct damage and indirect damage. Damage causing acts or illegal acts, namely enriching upon the life, health, honor, dignity, reputation, property, rights, and other legitimate interests of others. There is a cause and effect relationship or causal link between the illegal act and the damage caused. So we will clarify the applicable laws in the analysis of specific case. First of all, it is the case of Alice and George. George report clearly state that the survey found no major structural problems and that the remedies were worthy of the asking price. However, in fact, George did not mention the damage of this crowd, specifically the dry rot, which caused the accident affecting Alice's health, namely Alice's broken leg, her wounds, and eradication of dry rot delayed the opening of premises for several months. Through the above proofs, pursuant to clause 1 and
3, Article 584, Civil Code 2015, on the basis for arising liability for damage compensation is it found that George has violated Alice's health, which took a toll on her health and her business profits when her workplace had to open several months later than planned. Therefore, in this case, George is liable to compensate Alice for non-constructive damage. Regarding the compensation mechanisms for non-constructive damages based on Article 590 of damages due to enrichment of health, Alice can consider the compensation factors mentioned as follow. Uh, reasonable, reasonable expenses for the treatment, fostering and restoration of health, and function lost or reduced by the person who suffered Alice because of her broken leg. Since in this case, Alice was economically impacted by the delayed opening of the premises, so she deserved damages commensurate with the actual lost earning. In addition, George is also responsible for another amount to compensate for mental loss that Alice suffered. This compensation will be mutually agreed upon by both parties in the event that Alice and George cannot come to reasonable mutual agreement. The maximum compensation for Alice is not more than 50 times the paid salary prescribed by the states, with a paid salary in 2021 of 1,490,000 Vietnam dong per month. As the summary of case states, Alice paid Happy Homes for a summary report. Nope, not yet. Yes. For a summary report from George, therefore, we can infer that George is an employee of Happy Homes. From this argument, based on Article 597, Civil Code 2015 on compensation for damage caused by person belonging to the juridical persons. Alice can also request the legal entity Happy Homes to compensate for non-constructive damage caused by its employee George, caused while performing a task assigned by the legal entity. So we move to the next case, the case of Alice and Industrial Kitchen Fitters Limited. According to the situation represented in the article, Alice signed a contract with IKF to retool the kitchen. They installed a new oven made by cinder. A week after the last visit opened, the oven malfunctioned. As a result, a wedding cake was badly burned, leading the bride's father to claim damages for breach of contract against Alice. Pursuant to Article 608 of Civil Code 2015 on compensation for damage caused by violation of the interest of consumers, individuals and legal entities that produce or trade in goods or service do not meet the quality standard of good and service, causing damage to consumers must be compensated. And
The question is whether IKF or Cinder will be responsible for Alice compensations to settle on which individual or organization will be responsible for compensation based, based on Section A, Clause 2, Article 23 of the Law on Consumer Protection 2010. Product trading organization and individuals are responsible for compensation. Damage caused by defective products is the organization or individual that produce the goods. In this case, it is supposed to be Cinder. So regarding defenses, considering the case that the defendant succeeded in proving that the value of the new ovens were due to a list, pursuant to Clause 2, Article 584 on credits for arising liability to compensate for non-constructor damage. The person causing damage is not responsible for compensation in case the damage is caused by force majeure events or completely due to the force of the interparty. And otherwise, by law. If the response proves that the new oven is damaged due to Alice falls, subject collected during use, failure to read the instruction carefully before use or something like that, then the defendant is not liable for non-constructor damages. So we move to the conclusion. For U.S. law, we come to the conclusion Alice was able to bring a lawsuit against either George or Happy Homes Building Society or both to claim for damages under negligent doctrine. With the arguments that there is a defect in the product which caused injury, loss, and damage to Alice. In addition, IKF has closed, so the liability for non-constructor damages for Alice shall be exempt by Cinder because of the strict liability products. And under Vietnamese law, pursuant to Civil Code 2015, Alice is able to sue not only George but also Happy Homes for non-constructor damages due to compromised health. And Article the Post Civil Code 2015 and the Law on Consumer Protection 2010, Cinder is responsible for compensation for damage caused by defective products to Alice. So that's it for our presentation. Thank you for listening. If you have any questions you would like to ask our group, please raise your voice. Thank you.
Okay, thank you very much for the presentation. Anyone in the class have any questions? Please feel free to ask. Anyone have any questions? Anyone have any questions? The groups, could you please show the slide with half the full problem solving questions that I sent you? No questions? Before you move on this presentation, I just want to ask whether group 5 already sent your presentation to me. Group 5 member, are you in the class?
We have sent it for the in our presentation in last week.
Okay. So last week you sent it to me last week. Thủy, right? You are in that group, right?
Yeah.
Okay. Yeah. Probably because you didn't say LE class, right? So I saw your representation, but I didn't know who. Your groups also have Quang Vinh, right?
Yeah.
Yeah.
Group leader
Because-
Quang Nguyễn Minh.
Right. You didn't say the class in the slide, so I didn't know whether it is what class because I am teaching several classes at the same time. Okay, I got that already. Okay. All right. Now, no one have questions for the group. Just for a second, I just want to save the group file first. Otherwise, I will lose it. Okay. So I just want to ask you about two facts, whether those facts actually affect your conclusion or your application of the law. The first is that in the report, okay, the summary report from George. And in that summary report, it concluded, this report is for valuation purposes only and will not give rise to any legal liabilities. Okay. My question is that whether it affect your answer. That's the first question. The second question is that IKF, the facts that IKF had gone out of business, okay, whether that facts could affect your answer. Are you with me? Is it clear enough?
Yes, it's clear, Miss.
Okay, yep.
So regarding the first,
Sorry. I just want to ask one more thing, that in your conclusion, you said that contract law will not apply, right?
yes,
Yes. And you already explained the reason that why contract laws do not apply. You said that the reason that you pointed out is that the report that George sent to Alice already said that this report will not give rise to any legal liability, and this is only for valuations purposes only. And we can conclude that contract law could not apply in this situation. In fact, I'm not quite sure why that statement make contract law inapplicable in this case. Also, because it's relating to the fact that I just want you to make clear about. Okay, are you with me?
yes, Miss.
Yeah, all right. Yep. Okay.
So can I have just 1 minute to discuss? Yeah.
Right. You can discuss with each other before answering the questions.
Yes, Miss. Can I answer the question?
Yeah.
First one regarding the first question, it is whether the sentence "this report is for valuation purposes only and will not give rise to any legal liability" will affect the conclusion of F group. So, according to F group and what we observe from the fact, we can see that the Alice Pet Happy Home forced a summary report from chart. So uh, from our point of view, this is a contract here because we have the consideration pet, Alice Pet Happy Home. So we have the consideration and the intention to create a contract. Whether this contract is expressed or implied, or it's in oral or in written form, but we have the consideration and the intention to turn into the contract. So our group think that is here it create a contract to a relation. It have a contract here. And for the sentence, the report is for valuation purpose only and will not give rise to any legal liability. So due to the contracts, so this sentence is just can relieve the liabilities of charge from the contractual relation, from the contractual liability that charge held under the contract. However, with tort law, we provide the protection and for the variety of injuries that a person had to suffer, and is the contractual relation is not one of the elements to fall under the tort laws, or in other words, it's not necessary to prove whether it has a contractual relation under tort law or not. So even there is his conclusion, hey, this sentence, our conclusion for the legal issue one is not doesn't change. Alice still have the right to choose charge or the Happy Home Building Society under the negligence doctrine. And for the second question is that the IKF has gone out of business. So in our presentation, we have already pointed out that because they gone out of business, so we have no legal route to choose them. So we conclude that in this case, Alice can sue the cinder inks. Moreover, according to our research under the US law, if the IKF has gone out of business, so we will have the government and the insurance agencies, the government department and the insurance agencies, they will come into existence and discuss about a solution from the insurance company for the injuries that Alice has suffered. So that our group answer for the two questions.
Okay. So for the first question, you said that contract law, the language that you use, that contract law could not apply in this situation. I think that is not an accurate conclusion. You should say that Tort could not be liable under contract law. Okay? Not saying that the contract law could not apply. Because if contract law apply, because only when contract law apply, you can come to the conclusions that Torts or Torts will not be liable, right?
Yes.
Yeah.
I
But
see.
but how about Happy Homes? Whether Happy Homes could be liable? Yeah, actually, the report was sent by Chalk, right?
Yes.
And was sent to Alice by Chalk rather than by Happy Home, right?
Yes, it's
Or,
by Tort. But on behalf of Happy Home Building Society, that's what we think.
yeah, with the mortgage. Actually, its survey were conducted by George, but for Happy Home Building Society.
Yes.
Yeah. And Alice pay Happy Homes, not pay George. So whether George could be liable for Alice under negligence, and your conclusions is that no, right?
No, we say trust is liable under the negligence. However, trust is an employee of Happy Home. So Alice here in this situation will have the choice to either choose trust or Happy Homes Building Society or both under the negligence doctrine.
But and then either George or Happy Homes Building Society, and in this case, more likely that Happy Homes Building Society could be liable. That's what you mean under the tort of negligence?
Yes, because we think that the one who conducted the report is Tort, but conducted on the behalf of Happy Home.
Yeah, I understand that point. But I just want to ask whether is there any differences available to George or Happy Homes Building a Society in this case? Negligence, but what types of negligence here? To be more specific, what types of negligence? What specific types of negligence here? Yeah, you say about vicarious liability, but vicarious liabilities mean the situations when one person liability is shifted to the other person because of their relationship. So by saying so, you may say Happy Homes Building Society could be liable for tort negligence. But what types of negligence to be more specifically?
Yes, Miss, can we discuss with at my group one more?
Okay, yep.
Miss, can I ask? Your question is that is there any defense available for charge? Is this right?
Yeah, either available to church or to Happy Homes Building Society.
Okay.
Before that questions, there is a questions that what is the specific tort that either church or Happy Homes Building Society could be liable. What types of specific tort?
Yes, Miss. Yeah.
Hello, you have the answer?
Yes, Miss. Let me
Okay.
try. So
Yeah, just try your best.
yes,
Yeah.
I would like to answer the second question first. Is there any defense available for Charles? So after discussing, our group think that the opposing parties, which means Charles, can use the defense of comparative negligence in this case, because when we research about the report for the valuation process, for the mortgage valuation process, it says that it's on the benefits of the lender. Here is the Happy Homes Building Societies, and the one who received the report, which in this case is Alice, cannot 100% rely on the report for to know whether it has no defects or for the values of the property. So if Alice cannot rely on 100% on the report, so Charles can use the comparative negligence in this case, and his will prove that the injuries from Alice is partly at fault for her injury. That's our group answer for the second question.
Okay. The key issues that you need to consider is what types of tort. You said negligence, but what specific types of negligence? If you can find out, and then it could be easier for you to find out defense, probably defense.
Yes, let me see.
Anyone in the class have any idea? Anyone in the class have any idea about a specific tort? Anyone in the class have idea about that? What do you think about professional negligence or negligence misrepresentations? Professional misrepresentation. Anyone could consider that? Or in other words, professional malpractice. Have you ever think about these types? You see my screen? Professional malpractice. You say that under contract law, you may not be able to successfully sue Happy Homes or Tort because There is provisions in the contract that release their liability, but how about under professional malpractice? Evaluation services is one type of professional. And if he failed to evaluate the house, okay, you look at the conclusions of the report. This stated that there were no major structural problem and that the premises were worth the asking price. No major structural problem. But you can see here in the facts on moving in, Alice discovered severe and large-scale ride rot when she fell through the storeroom floor and broke her leg. You can see that whether it is a major problem, structural problem. If it is major structural problems and the report say there were no major structural problem. However, there is a defense, and the defense in this case is appropriate disclaimer. But you need to determine whether, there is a disclaimer. The disclaimer you can see here, this report is for valuation purposes only and will not give rise to any legal liabilities. So whether it could be reasonably acceptable if in the report, and also you charge for it, okay? You could say will not give rise to any legal liabilities. You may argue that it could not be acceptable, or you may argue that it is not an appropriate disclaimer, even though the reports have a disclaimer, but it is not an appropriate disclaimer. You may argue so. Okay, so once again, I want to emphasize that whether you say yes or no is not very important. The more important thing is that you need to argue, you need to give arguments, explanation, and connect your argument with the facts given in the case. Are you with me?
Yes, Miss.
Yes. And one more thing about the facts that IKF had gone out of business, and you said that insurance company could be liable to pay for damages if IKF had gone out of business. I think that what you think about insurance, but in this subject, we do not talk about insurance. We talk about negligence. Tort, we talk about tort, we talk about negligence, we talk about product liabilities. You mentioned that IKF actually liable under strict liability, right?
Yes, Miss.
Yeah. But then if IKF had gone out of business, what you could do about product liability, we do not talk about insurance because our subject doesn't deal with insurance. Anyone have idea? Okay, so I just want to tell you that one very important thing is that under strict liability, anyone in a distribution chain of the products could be liable. So in this case, if IKF had gone out of business, Alice can always take a legal action against Cinder Inc., who manufactures the ovens. All right? Understand?
Yes. In our answers, I also mentioned about this point that Alice had the right to choose Cinder's.
Yeah, but my questions is focus on the facts that IKF had gone out of business. So in order to answer that questions, I ask the questions in order to check your understanding. Okay? If you hear that question, you could say that, okay, she can take legal actions against Cinder Inc. All right? Because
Yes.
anyone in the distribution chain of the products could be liable. Okay? All right?
Yes, we understand, Miss.
Okay, I just asked the questions in order for you to make it clear. Okay, thank you. All right, so we can stop here for now, everyone. Okay. All right, see you tomorrow. We have a section tomorrow at 8.